Oh. The record in the matter of the people of the state of Michigan versus Angelina Brew, file number 24-01733, council affairs.
Morning, Your Honor. Joel Martinez, appearing on behalf of the people of the state of Michigan.
Your Honor, Fred Blackman, on behalf of the Baker, may I approach you?
Yes. Okay, today was the date set for final pre-trial. I do have a advice of rights and plea information sheet here today, so there's going to be a plea, is that correct?
Yes, Your Honor.
I approach you.
Thanks. Okay, so the people are offering for you, Ms. Brew-Breaker, to plead guilty to count 1, attempted police officer was seen obstruct and oppose. They'll dismiss count 2, and there's a Brew agreement of no plus jail. Is that accurate? You want to accept that offer?
Yes, Your Honor.
Okay, you're right. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
The rights and rights, it has a signature page. Is that your signature?
Yes, ma'am.
You went over these rights with your attorney?
Yes, sir.
You understand each of these rights listed here?
Yes, ma'am.
And you're willing to give up those rights in order to plead guilty to count 1?
Yes, ma'am.
So that means you're gonna give up your right to the presumption of innocence. You're innocent until proven guilty. Did you understand that?
Yes, ma'am.
You have the right to require the prosecution prove your guilt at trial. They have to prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial, not have silence be used against you, or you can waive your silence and testify for yourself at your trial if you like. You have the right to subpoena witnesses to your trial to testify on your behalf. And you have the right to present evidence that you believe show a defense to the charges being brought against you. Those are all rights you're willing to give up.
Yes, ma'am.
Anybody threatening you to get you to give those rights up?
No.
Has there been any promises made to you in exchange for a guilty plea?
No.
Are you currently on probation or on parole?
Yes, ma'am.
Which one?
Probation through Eaton County.
They are already aware.
Until when are you on probation?
Next July. But if
For a year, about a year.
Yeah.
I understand that by entering a guilty plea on this file, this could result in a conviction that you may need to report to your current or future employer.
Yes, ma'am.
It also could have an impact on travel or immigration status. So you may want to go on vacation to a particular country and they could deny you entry because of it. You understand that?
Yes.
As to count 1, attempted police officer assault and resisting, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yeah.
Well, he said, yeah. What do you believe?
Yeah.
What did you do to make yourself guilty of attempted resisting an officer?
I interfered with what the police were doing. Like I interfered with I guess a lawful stop or a police encounter.
They were stopping you or someone else?
They were talking to somebody else and I interviewed.
Okay.
Ruben, I'm stating down your question. You had a dispute with your significant other, is that correct?
Yes.
Okay, and after that dispute, the police were called, is that correct?
Yeah.
And then you interfered with that.
Yes.
What city did that happen at?
Lansing,
What's the address?
3211 Trappers Cove Trail.
Ingham County?
Yeah, in County.
Any additional factual basis?
No questions from the people. Thank you.
Or dissatisfied with the factual basis on such a plea if I being made voluntarily and intelligently. I normally would refer her to probation. However, she's just started a term of probation for a year, so I don't know that it's meaningful for her to do 2 terms of probation
Yeah, that probation was extended for a year because it was initially 2 years and then it got extended to another year.
Because of some allegations, this was one of them.
Oh, okay, so she was originally on a term of 2-year probation,
It was a 1 year, but they.
1 year,
extended it.
got it, okay, so I was gonna say, they extended 2 year, okay. So you have additional 11 months to go on probation at Eaton County, correct? You can make allocution.
That would indicate that on that particular date. What she indicated to you actually happened, there was, since that date, been no problem. She's employed, she's doing everything she needs, and she also is complying with everything in probation. Now, in the future, so that's the plan.
$75 fine, victim rights, but $50 state minimum cost, plus a fine of $500. And you're gonna pay.
Yes, this is.
We have CCTV here.
I don't know if you pay within 60 days. Up to you on your probation in the county.
Thank you.
You're all set.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Elias Griffin, the file number is 23-02809, council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people. First making a motion to practice under Michigan Court Rule number 8.120.
Who's granted?
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Griffin. I have not seen him this morning.
We had any communication with him? this
I
week?
reached out to the phone number we had on file yesterday. That number is out of service. I sent him an email, have not yet received a response. I did see note that he was in contact with his prior attorney. However, I think it's been some time since then.
Okay, I'll show them. We have witnesses here.
I did not have the necessary witness appear on this case, Your Honor. I haven't had great contact with our office on that.
Note that in the file, but they will be issued.
Thank you, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Jakara McAnallen. File number is 18-01189. Yes, for the record.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Jacob Brown, on behalf of Mr. McLean.
Good morning, Judge.
Good morning, how are you?
Right.
Okay, today is the date set for a final plea trial, and this is for, well, it's not a jury trial, but it's for a retail fraud. Third degree. I have a note though that there was a plea.
Yes, Your Honor. I'm filling out the sheet right now.
Okay, is that to the attempted retail fraud third, or is there a new offer?
That was
Yes,
the-
Your Honor.
She has an advice of right.
Yes, I can put it.
You want to plead guilty to the amended charge of attempted retail fraud in the third degree, ma'am?
Yes, ma'am.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yeah.
Okay, you can put your hand down. Ms. McLean, is that your signature on this page?
Yes, ma'am.
And did you go over these rights with your attorney?
Yes, I did.
Do you understand them all?
Yeah.
And you want to give them all up today in order to enter a plea to the amended charge?
Yeah.
Okay, so that means that you would be giving up your right to have the presumption of innocence, because you're innocent until proven guilty. You recognize that?
Yeah.
Okay, you have the right to require the prosecution prove your guilt at trial. They have to prove each element of the charges being brought against you beyond a reasonable doubt. You understand that?
Yes.
Okay, you can be silent at your trial by right and not have silence be used against you, or you can waive that and testify on your own behalf if you'd like at your trial. You recognize that?
Yeah.
You also could subpoena witnesses to testify on your behalf, and you have the right to see, hear, and question in court any of the witnesses that they call against you. You understand that?
Yeah.
Anybody threatening you to get you to give up these rights?
No.
Promises made to you in exchange for you entering a guilty plea today.
No, Your Honor.
Probation?
No.
Okay. You understand that a guilty plea could have impact on travel or immigration status that you may see. So you may want to move to another country, or you may want to just go there for vacation. You could be prohibited from doing that because of this conviction.
I'll say yes.
You understood that? You can say, you don't have to lie if you didn't understand that.
I know I did.
Okay, did you need time to talk about
No,
that?
I'm good.
Okay, okay, and so,
Thank you, though.
no problem. And you understand that this is a conviction that you may need to report to your current employer, or you may need to put this on a future job application.
Yes.
As to count one, amended count one, which is attempted retail fraud in the third degree. How do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. This claim on December 31st, 2017, we were present at a Target store at 500 East Edgewood Boulevard in Lansing.
Yes, they had these dates wrong. That was 2016, not 2017. It's been 8 years ago.
Tell me what happened in
Okay,
2016.
2016. So then I had just had surgery and I was in the buggy. I'm shopping around and I was on Xanax. I just told on, so I just had ankle replacement surgery. And I had some things in the cart. I was driving through. So I was sitting down to pay at the self-checkout. All the things were not paid for at the self-checkout. So he came up to me and stopped me. And he said, "Were you coming in?" And I was like, "Yeah, sure."
So that was intentional, that you didn't pay for everything, or did
No,
you
it wasn't.
accidentally?
It was accidentally. I mean, I was sitting down in the buggy and those buggies are deep. So I'm thinking like, he
Understandable.
could have came and helped me.
Understandable. I'm not accepting her plea. That you did, you're not telling me that you stole anything, that you accidentally didn't take the stuff. So make them prove it.
No, I just want this done.
I can't take your plea
Why?
because what you just told me doesn't meet the standard for me to take your plea.
Oh yeah, I intentionally drove.
You just told me that you didn't.
Okay.
So we'll move forward with trial. Was it set for jury trial today?
Was the answer?
I'm assuming you called off your witnesses?
Yes, Your Honor. We did have a target employee show up. I know, Your Honor.
A target employee from 2016?
Yes, Your Honor, we did.
Well, we'll reset it. She can't give me a factual basis, so I can't take it.
Yes,
And
Your Honor.
changing it now doesn't help. You already sworn to tell the truth under oath. Now you're telling me you just want to get it over with, so you're changing your story.
I mean, because this is what happened.
Exactly. So if that's what happened, then you're innocent until proven guilty.
This is holding my life up.
I recognize that. It's been holding up your life for a long time.
No, it hasn't.
This
I
is a
didn't even know
2018
that
file.
I didn't even know that I had this one. I even tried to turn myself in on Zoom, and the woman wouldn't even let me turn myself in.
This warrant was signed back in 2018.
Yeah, and when I tried to turn myself in on Zoom,
When? We didn't have Zoom in 2018.
no, in Zoom, just when I found out I had this
Agreed.
warrant.
But this case has been pending since 2018, so we're not gonna rush it, nor can I bypass the criteria just to get it over with for you. I'm not allowed to do that. And your attorney can explain that to
I
you
mean, it
further.
just happened.
I recognize that it just happened, ma'am. What you're not understanding is that there's elements that must be met. That's why I asked you what you did to make you guilty. What you told me under oath doesn't give me cause to believe that you were guilty of this action. So I can't accept your plea, okay? You need to go have further counsel with your attorney, okay?
That it?
I'm gonna get you a next court date.
October 22nd.
October 22nd at 8 a.m. for trial. It's, I'm sure, the oldest case on that docket, so it's priority. Do you have any questions for the court?
Yeah, what happened then?
It's gonna be set for a jury trial. Okay, on the record in the matter of the people of the state of Michigan versus Sonny Miguel, file number 24-01896.
Morning, Your Honor. Case marked hearing appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Sonny Miguel, who is approaching council table now.
Okay, today's the date set for a final pre-trial of domestic violence. We have necessary witnesses here.
No, Your Honor, I did make contact with the necessary witness, Mr. McCrane, yesterday. He made very clear and in no uncertain terms he would not show up. He does not want to participate for the people who are unable to proceed.
Given the representations made by brother counsel, I would make a motion to dismiss this file.
Motion to dismiss is granted without prejudice. People do have the right to reissue this charge against you, okay? You understand that? Yes. Okay, we'll get you a copy of your dismissal in just a moment. On the record in the matter, the people of the state of Michigan versus Tanya Trip, file number 24-01961, council appearance.
Morning, Your Honor. Case marked hearing appearing on behalf of the people.
And I apologize, this is Mr. Raleigh on this one.
She needs a copy of that one. She needs a copy of that. I just asked you.
Did you call the case, John?
I did.
Jacob Raleigh representing Ms. Tripp on case numbers 23-03087 SN and 23-03089 SN.
Okay, so this was the date that was scheduled.
I apologize, Your Honor, and if I may, there's two of us on this. Assistant Public Defender Lauren Sutter appearing on behalf of Ms. Tripp in file 24-01961.
Missing all the files. Yeah, I was gonna say, I only called one file number, I didn't call three.
I apologize. She's got a case at 8 AM in trouble.
Got it, okay. I'm dealing with the final pretrial right now. What's going on with the final pretrial?
Your Honor, I did attempt to make contact with the necessary witness on this one. Our office has attempted several times. It looks like from the notes I have, we've never really had successful contact. I also don't see them here today, so it would be unable to proceed.
How do we want to proceed with that?
Thank you, Your Honor. Given the representations by Mr. Mercurian, I would make a motion to dismiss on that file.
Motion to dismiss without prejudice is granted, so Ms. Tripp, they do have the right to reissue this charge against you. You understand that? You don't understand that? Okay, so do you understand that this could be reissued against you within the statutory timeframe? Do you have any questions for the court? Okay, we'll get you a copy of your dismissal in just a moment on that.
Thank you, Your Honor.
Okay, and then we have people of the state of Michigan versus Tanya Trip, 2 docket larges, 23-03087 and 89. And I already have your appearances at this point for the how we handle dog license and dog at large.
Yes, Your Honor, I have received proof from Mr. Raleigh through his client that she has both gotten the dog licensed and fixed the issue of defense that resulted in the at-large. So at this time, the people would dismiss in the interest of justice.
Motion to dismiss is granted. You're all set. The record in the matter of the people of the state of Michigan versus Isaiah Williams, file number 24-01944. Appear to the record.
Morning, Your Honor. Case marked hearing and hearing on behalf of the people.
On behalf of the siblings.
Okay, this is a final pretrial for domestic violence. Do we have necessary witnesses here?
Yes, Your Honor, the necessary witness, Cassandra Williams, is here.
Okay, how are we proceeding?
Under my client intends to proceed to trial.
Trial is scheduled to proceed September 17th at 8 AM. I'm supposed to be on jury duty that week, so I'm not necessarily blocking my docket. Because I just had jury duty last year. I don't know why I just got pulled again. I'm almost positive no one selected me. But in the event that I gotta go over there, this case might get rescheduled, but it's scheduled to go on the 17th. Do you have any questions? We'll get you a copy of your notice to appear. Any additional matters for the record?
Nothing further from the people. Thank you.
No, Your Honor, thank you.
Okay, you're all set. Okay, on the record in the matter of the people of the state of Michigan versus Michael Dwayne Barron, file number 23-01767.
Morning, Your Honor, Angela Delgado on behalf of the people. Your Honor, we had sent an email to the court. We wish to speak to the court in chambers. The court's willing to do so. Court needs to pass us to do other matters. That's fine.
No, we can do it now. Mr. Seabrook is next, and he's downstairs. Bianca Swinford is present.
Yes, Your Honor.
Okay.
Yes.
Good
morning.
I believe, Your Honor, I did hear, and I got into a breakout room with Ms. Booth there. She does have proof of licensing. I just haven't received it yet, so I don't know how to handle that. But perhaps we could just set for a final pretrial, Your Honor, to allow some time for that proof to get over.
I'll just set it for me.
Good morning, Your Honor.
Good morning, how are you?
Good, Your Honor. Thank you. Mr. Swinford does have proof of all three dogs, and I spoke with counsel, and I will be emailing that shortly after this meeting.
Next available date.
August 27th at 1:30.
August 27th at 1:30 is the next date on that, on these files. So you're all set
Great.
for
Thank you,
today.
Your Honor.
No problem.
Thank you.
Okay. On the record in the matter of the people of the state of Michigan, this is Michael Barron. This is file number 23-01767. Answer the record.
Good morning, Your Honor. Angela Delgado on behalf of the people.
Good morning, Ashley Gallagher, on behalf of Mr. Barron, who is present in the courtroom and standing to my right.
Your Honor, today's the date and time set for a bond violation hearing in this matter. It's my understanding that the defendant has yet to be arraigned on that bond violation. So I presume the court will wish to do that. We have also then negotiated a plea agreement that resolves both this bond violation and the pending charges in this particular case that are set for trial next week. We filled out a pretrial form just showing that plea. Would the court like a copy of that?
Yes, please. Thank you. Okay, so I have a bond violation here that you need to be arraigned on. Stem from this police report here. Case number 2492602-691, alleging that on or about August 3rd, 2024, at approximately 1:32 a.m. In the area of Mark's Watershed, Hazlet, Michigan, you allegedly violated the terms of your bond conditions by disturbing the peace, and that the night in question that you were visibly impaired from the use of alcohol is the allegations. So you do have the right to have a contested hearing on the violations. You have the right to have your attorney represent you at that hearing as well, because if you're found to be in violation of your bond, that's a contempt of court order. And so you could be sentenced to 93 days in jail for contempt and or up to $7,500 in fines. You understand that?
That's right.
And the offer that the people are giving is that you plead guilty to the pending bond violation that I just arraigned you on, that they will dismiss the remaining counts in your underlying file, which is counts 3 and 4. So as to the bond violation, how does your client want to plead?
We plead guilty.
That's correct, sir?
That's right.
Okay, raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Okay, you understand your right to have a hearing on the bond violation? You want to give up that hearing and that right? Anybody threatening you to do that?
Okay.
Any promises being made to you if you give up your hearing? As to the allegations that you, on the date of August 3rd, 2024, violated your bond by using, consuming alcohol, how do you plead?
Guilty.
Can I have a factual basis, please?
On August 3rd, 2024, about the Watershed Bar, Michigan.
Yes, I would.
At that time, were you on bond for this case?
Yes, I was.
Was one of your bond conditions not consume alcohol? And you knew at that time?
Yes.
Okay, and did you consume alcohol?
Yes.
Any additional questions from the prosecution?
People are satisfied with the factual basis of the plea, Your Honor.
The court is also satisfied with the factual basis. I'll accept your plea. Finding that you may plead voluntarily and intelligently. So the people are going to dismiss the remaining counts. I think I need a knowledge for that.
I can do that, Your Honor.
That's the print one.
If you would do that, that would be wonderful. Otherwise, I can print one.
I think we do that. He has another matter pending currently.
He does. He has a, I think it's a disturbing the peace. I was just pulling it up on the 55th website. I think it's a disturbing the peace ticket that I think is being prosecuted by the township attorney in 55th District Court.
Is that the only other matter he has pending at this time?
That's my understanding, yes.
I'm gonna set this for sentencing on the violation.
Are you?
Yeah, I'm gonna have a meet with probation. October 22nd. And October 22nd at 9 is your sentencing date, okay? You need to appear in person. Okay? Yes,
Yes, ma'am.
You said October 22nd, Your Honor?
correct.
Thank you.
When you leave here, you'll go down one floor and check in with probation, because I want you to have a pre-sentence report prepared before your sentence, okay? Has he had a substance abuse assessment recently?
No.
Have any questions? We'll get you downstairs in just a moment. You can have a seat. Delgado was here, but we didn't have an interpreter. So that.
No.
Because I didn't know what to put. 9 a.m. for sentencing.
Thank you.
Yeah.
I must be getting old. I can't hear you over the fan.
No worries.
Yeah.
We're all set on that one.
For jury duty for 54A.
No, 32nd.
Oh, no fun.
Yeah, and I was just there, but it wasn't, it was May of last year. Let me really, who's here with the,
With Mr. Seabrook, I am, Your Honor.
well, who's here with Delgado?
I am.
We don't have an interpreter. Gotta reset it, because we don't have an interpreter. Yeah, the other, I have to. You do September 3rd at 10. September 3rd at 10. September 3rd at 10.
I was just looking at options for my. His wife is here.
You want it set for final pre-trial? We go to 8 a.m. September 10th. September 10th at 8 a.m. Yes.
I was also hoping to be heard on bond.
Okay, on the record in the matter of the people of the state of Michigan versus Ivan Delgado, file number 24-00429 SM. Council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Ashley Gallagher, train appearing on behalf of Mr. Delgado, who is present and sitting to my right.
You understand what I'm saying? And then I can't proceed. I mean, I guess you could, but she's not not a certified interpreter, so. And you want to make a bond motion, I need to be able to have confidence that he's going to be properly advised as to what your requests are, and if I make a change, what those changes are. What is the request?
Requesting to have the GPS tether removed.
Based on what?
Yes, Your Honor, I understand that this is a stalking charge and the GPS tether was placed to keep the victim in this matter safe. However, there have been some issues with the victim and those associated with them. There have been reports made by Mr. Delgado and his family to the police about harassment. I have spoken to Mr. Markarian about this. I think he's aware of them peripherally, but doesn't have a report or anything. So at this point, I don't think that the GPS tether is serving its intended purpose, and I would ask it to be removed.
Do the prosecution want to respond?
Yes, Your Honor. First, I would say I'm a little uncomfortable doing this without a certified interpreter. I just want to put that on the record.
I'm not making a ruling.
Yes, Your Honor. I do think because of the nature of the charges, the fact that it's a stalking, there's certainly a concern. I would leave it to the court's discretion.
You saying there's a police report?
There should be 4, actually.
Okay.
I've seen case notes in our file about communications from defense counsel about these reports, Your Honor. I don't have any reports or anything like that.
Okay, well, let's set this for a hearing on the bond motion, so we get an interpreter here. And then that'll give you time to get the police reports. August 30th. 9:30. August 30th at what time? 9:30. 9:30. Any additional matters for the record?
Nothing further from the people.
No, Your Honor.
You're all set. Yes, I made a copy for both of them. Okay, on the record in the matters of the people of the state of Michigan versus Kerry Seabrook. File numbers 24-01395, 23-03281, 23-03232, 24-00608, 24-00609, 24-00610, 24-01023, 24-0117879880818283, 24-01465, and 24-01466 and 67. Council appearance, please.
Abigail Wilson for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Seabrook. In most of these files and appearing on behalf of Mr. C. Feigelson for Mr. Seabrook on, I believe, an FY file that we're also going to be trying to resolve today.
I'm just review. I don't see an FY file on my document.
If you're on the docket for today, Your Honor, it is set before yourself this Friday. I had emailed the court last week to ascertain as to whether or not we could resolve that file today with a plea that's been worked out between myself and Ms. Wilson here. And that is file number, just give me 1 second, load my screen.
24-01707-FY. And it would be a misdemeanor for this then.
You have a plea.
I do, Your Honor, if I may approach.
So the offer is from the plea, global resolution from the plea to use on file number 24-01707. That's the file I actually need. I don't even need those ones. We're off the record. Okay, so he's gonna plead guilty to 24-01707, and the remaining will be dismissed. People will not pursue witness interference charges and recommend dismissal on bond violations and dismissal of dog cases.
That is correct, Your Honor.
Still have these dogs?
I believe he's relinquished 1 or 2. I'm not sure about the status of the remainder.
Your Honor, he's relinquished 4 of them, several other in the care of someone else right now.
Okay. Have an advice of rights. What is the bond violation? 9-5. Let's see. I got a bond violation from the 6th of June. Violation from the 17th of July.
May I approach with the advice of rights?
And then bond violations from the 16th of August. You will think I'm dismissing 3 bond violations for the plea offer. So I can put him on probation for him to violate my probation's orders.
No.
I'm not dismissing the bond violations. So you talk to your attorney about what you want to do. I'm not dismissing the bond violations. They're, as alleged, a complete disregard for the court order. So you can have time to talk to him.
Your Honor, just before Ms. Sutter goes, we have a possible idea. If he were to plead to perhaps 1, would the court be inclined to dismiss the other 2?
the way they have this written up, it's written up as 3. There's technically more than that because of the GPS tether, which he came to me and told me that he wanted to be within a certain time or zone, so he can go to work. And I amended it to allow him to do that, but the timeframes that I have here are not work timeframes. And then there's at least 2 violations for making contact with the protected party. And I think the 7th one is mentioned about not to pick up a new case, which I never concern myself with that. So yes, he could address at least one of those bond violations. Mr. Yang?
Good morning, Your Honor.
Good morning. You're here with Cheyanne Armstrong.
That's correct, Your Honor. We're scheduled for sentencing today.
Cheyanne Armstrong? Okay.
Yes, Your Honor.
Okay. On the record, in the matter of the people of the state of Michigan versus Cheyanne Armstrong in file number 24-01376. Council appearance.
Morning, Your Honor. Case Mark Aaron, appearing on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Cheyanne Armstrong. We were both present via Zoom.
Okay, Ms. Armstrong, today's the date scheduled for sentencing. This is for a misdemeanor retail fraud, 2nd degree. I do have a pre-sentence report that was prepared by our probation department back on the 15th of this month. Mr. Yang, did you get a copy of it?
Yes, Your Honor. I have received a copy. I have forwarded that to Mr. Armstrong. We have reviewed it, and there are no additions, corrections, or deletions.
You can make allocution.
Thank you, Your Honor. I'd ask that the court grant Ms. Armstrong HIDA. I think her statement in her paragraph that she wrote in the report kind of sums it all up. She made a bad decision. She, based on the totality, I've explained to her the video and the interaction she had with the officers. This could have gotten a lot worse for something, honestly, that she probably shouldn't have been doing, and it's small. The interaction escalated fairly quickly, and I've spoken to her about that other interaction with the officers. But I think HIDA is appropriate for her. I think she'll take this seriously. She's been contrite about it and has worked with me on this. And so I'd ask that you grant HIDA, waive as many of the fines and costs as possible, as I do believe she is indigent. She is still looking for employment at this time. Thank you, Your Honor.
Where is she looking for employment at?
She was looking for home health care last we spoke. Has that still, Ms. Armstrong, is that still accurate?
I've been applying at a lot of jobs. The most recent job that I applied for was Amazon and Family Dollar.
Does your client want to make any additional statement today?
Ms. Armstrong, is there anything you'd like to say to the court today?
No.
I reviewed the pre-sentence report. And the recommendation, which is for a term of probation. I think it's appropriate. So I'll adopt the recommendation, which will be sentenced as follows. I will grant status under the Homes Infiltrating Act. While on probation, you need to obtain employment and provide verification of that.
Okay.
6 months probation, reporting via Zoom. You're not to engage in any assaultive or threatening behavior, nor are you to purchase or possess a firearm, ammunition, or weapon of any kind. You're also not allowed to use alcohol or marijuana or a controlled substance while on probation. You understand that?
Yes.
You will be required to submit to random preliminary breath testing and urinalysis testing. You are responsible for the cost of that. Do you have any questions about your probation condition so far?
No.
There's $75 crime victim rights fee that will be assessed plus a $50 state minimum cost that you are responsible for. 6 month probation, there's a $30 per month oversight fee, so that's $180 in oversight fees. It's about $51 a month that you'll be responsible for paying, okay?
Okay.
I'll waive discretionary fines and costs at this time. Okay. Lastly, there's an advice of rights as to probation. It states that you've been placed on a term of probation before the 54A District Court, and your conditions are individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, stalking, or an offense where the defendant is guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the right to request early discharge from probation after you've completed all the required programming, and you've not violated the probation status within the 3 months preceding your request. You must have completed at least half of the original term ordered by the court. You could fill out a copy of your request for early discharge, which is the MC 512 form, notice regarding eligibility for early discharge form, which is located on the court website. Once you complete that form, you need to file a copy of it with the court and serve a copy of it on the prosecutor's office. The prosecutor has 14 days to respond in writing with any objections to your early discharge from probation. Do you have any questions about that?
No.
You'll check in with our probation department within the next 2 days. You contact them to make sure they have your information accurately so that you can go over the judgment of sentence, okay?
Okay.
Let's see. Your address has not changed since your last court appearance before me?
No.
Okay, do you have any questions for the court?
No.
Any additional matters for the record, counsel?
Nothing further from the defense. Nothing from the defense, Your Honor. Thank you.
Thank you, you're all set.
Thank you.
You're welcome. For the record, in the matter of the people, actually, Ms. Sutter's not in here, isn't she?
No, she's in,
Okay, we've not seen Cottonham.
No.
Should have been sure.
And I know that is the one that Ms. Sutter did send an email to the court.
I have the email. I'll address it when she comes back.
Thank you.
Okay. Nobody's in the hallway?
there's a one gentleman, but I think he is for Flores, correct?
I'm about to go to a actually, mother just sit up. I can't hear nothing either.
What's your name, sir?
Douglas Carter.
Ms. Nyberg, do you have your client with you at all?
He's supposed to be here, Your Honor, and I'm nervous. I just looked at your windows and I don't see him. I will reach out to him right now.
Oh, no reason to be nervous. He's got 2 minutes till 10 o'clock. It's not late yet.
That makes me nervous.
If he was there, I was gonna call your case, but we'll see.
Okay, I will
There's no one
text him
outside.
just to make sure. Thank you, Your Honor.
Did you see anybody?
Are you still in there? I'm gonna push you in there. Yep, stay right here.
Okay, Mr. Carter, your attorney's logging in to talk to you, okay?
Okay, thank you.
I'm gonna put you in a private meeting room.
Okay.
Is that Darnell Carr?
Yes, this is me.
Okay, Mr. Carr. On the record of the matter of the people of the state of Michigan versus Darnell Montreal Carr. This is file number 16-03491 SM. Council appearance, please.
Morning, Your Honor. Casey Mercarian appearing on behalf of the people.
Okay, and then Mr. Carr is proceeding in pro per today, and this is for a motion to set aside a conviction from 2017 for 1 count of domestic violence. I do have a response from the Attorney General. They have no objection. His eligibility, and let's see here. Is the county prosecutor's office taking a position on this?
No, Your Honor, we'll leave it to the court's discretion.
Okay, looks like this is the only thing that's on your criminal history. What have you been doing since the time of this conviction, sir?
Work with somebody, I don't know who.
Give me just a moment. Let me put the jail back in order. Okay. Who was that? They go off? Okay, Mr. Card, you can continue to tell me what you've been doing since the time of your conviction.
Working, basically keep myself out of trouble, just learning my lesson and, really just trying to move forward and really just trying to like start fresh and stay on the right path like I've been doing. I mean, situation happened at the same time, really just been showing that, because of the situation that happened, I've learned, things what not to do and what to do. This is not to ever get in the situation again. something that happened that I wish that never would have happened, but moving forward and going on with my life and taking care of my family and doing the right thing, working and take care of my kids.
Okay, very good. I see again that there's no other conviction on your criminal history. That's being the only thing I see on here.
Yes.
Based on the review of the file and the information you're providing for the court, I believe setting aside the conviction as within the public welfare, I'll grant your request dated for today.
Thank you, Honor.
Thank you. You're all set, sir.
Thank you. Have a good day.
Same to you. Okay, Ms. Nyberg, I think your client is here now.
Yeah, he says he's having a problem looking at trying to turn on the audio, the volume. He's done this before, so I'm not sure why he's having confusion now.
This is a show cause. I don't know what's going on. You want, this was a show cost and it's supposed to be failure to pay, so you have to look up how much he owes. Let's see, that was.
It's $37.
And the person in jail. what's that?
It's Pritet, because I remember him having a tag on the front.
Oh, got it. What's your name in the jail?
James Pritchett.
Okay, okay. Go back on the record in the matters. People of the state of Michigan versus Carrie Seabrook. There was again an offer that was extended, and that was for Mr. Seabrook to enter a guilty plea as to number 24-01707. The use, and that the people would dismiss several remaining charges, and that they will not pursue a witness interference charge. There was a recommendation for dismissal of bond violations. And the people would dismiss the dog cases. The court has indicated that they will not dismiss all of the bond violations. So you have time to further counsel with your client. How does he want to proceed?
Thank you, Your Honor. Yes, I spoke at length with Mr. Seabrook regarding the situation here. There was also some discussion with yourself before I stepped out about the possibility of pleading to one of the violations, and I have discussed that. Be willing today to, along with the plea to the use and the plea to the domestic violence, to enter a plea to the bond violation of no contact violation that occurred on June 6th.
That's correct, sir? Is something wrong with your feet? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. And so you understand that you have the right to have a hearing on the bond violation? You understand that you have the right to have testimony brought forth and be represented by your attorney at that hearing before a violation can be sustained? You want to give up that right to plead guilty to the violation? Anybody threatening you to do that? Any promises being made if you plead guilty to the violation? Okay, as to the violation from on or about June 6th. That you violated your bond conditions by having contact directly or indirectly with a Kelly Hooks, and that you were within 1,500 feet of Kelly Hooks. How do you plead? Basis.
Thank you. Mr. Seaberg, on or about June 6th of 2024, were you under, at that time, a court order to not have contact with Kelly Hooks? And is it true that at that time, at or near 1101 Lathrop Street in the city of Lansing, Ingham County, Michigan, you did have direct contact with Ms. Hooks? I believe that satisfies the factual basis.
People are satisfied, Your Honor.
And the court is satisfied with the factual basis on that file. Let's see, and now file number 24-01707. The offer again is for you to plead guilty to use of methamphetamine. You want to plead guilty, sir? And you're still under oath. You understand your rights as it relates to this charge, because you do have the right in this matter to have a jury trial. And you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at your jury trial. You can remain silent and not have silence be used against you. You can testify if you like at your trial. You can subpoena witnesses to testify for you on your behalf. And you can present evidence that you believe show a defense to the charges being brought against you. You want to give up those rights? Has anybody made any threats to you to get you to give up all of those rights and plead guilty to use of methamphetamine? Anybody promising you anything if you plead guilty on this file? You're not on probation, correct? Understand that a guilty plea could result in a conviction that you may need to report to your current or future employer. It could also have impact on where you can travel. You understand that? You might not be able to go to Canada for vacation or another country. They could deny you entry because of this kind of conviction. You understand that?
Some countries have the power to deny you entry there for certain kinds of charges. Do you understand
Yeah, so.
What part don't you understand?
When I get out there to Canada.
You said, would you be? They could deny you. I don't know if you could go. You gotta ask Canada. But so you know how many countries are in the world? I just use Canada as an example. But there's plenty of countries that could deny you entry to their country because of this criminal conviction. You understand that? Okay. And so you also could be denied immigration status. So you may say, hey, I don't want to live in America anymore. I want to move to another country. And the country you select may deny you immigration status because of a criminal conviction. You understand that? Okay. As to the amended count 1 of use of methamphetamine, how do you plead? Because you believe you're guilty? Factual basis.
Thank you. Mr. Seaver, on or about June 6th of 2024, were you present at or near 1101 Lathrop Street?
Yes.
Is that in the city of Lansing, Ingham County, Michigan? And at that time, did you use a controlled substance called methamphetamine? And you knew it was methamphetamine at the time? Thank you, Your Honor. I believe that satisfies the factual basis.
People are satisfied.
Court is also satisfied with the factual basis on both files. Need to be freely, voluntarily, and intelligently made. This matter is set for sentencing October 22nd at 9 a.m. You need to meet with the probation department so they can provide the court with a pre-sentence report and a recommendation as to how you are to be sentenced, okay?
I apologize, Your Honor, if I may, you said 10 a.m. correctly?
9 a.m.?
9 a.m. Thank you.
October 22nd at 9 a.m.
Thank you.
Okay. Do you have any questions for the court today on that? No, my question is about, do you have any question about what I said? I don't want to hear about no bond. I want to know, do you have a question about anything I said?
Was that sentence today on bond?
I've not yet sentenced you on the bond violation.
Right now, she's just set sentencing for the use.
And I told you, you gotta meet with probation. And I want to know if you have any questions about that. Okay, I'm gonna require you to undergo a substance abuse assessment. You understand that? Okay. You have any questions at all on this file, not on the violation file yet? I've not sentenced you yet. I'm good. You and your attorney will get an opportunity to make an allocution or say some words as it relates to your sentencing. So I have not done that yet. Let's see. Any other matters on this file, counsel?
Not on this file, Your Honor.
Okay, you can make allocution on the violation.
Thank you, Your Honor. As I previously noted, I did speak at length with Mr. Seaver about this. He certainly understands the frustration of the court here. It's fairly based. He is accepting and acknowledging that he was pretty blatantly in violation of court order here, and that's never a wise thing to be. I have looked through his file. I believe he has currently served 75 days since his arraignment on the domestic violence file. If the court was so inclined, I would ask the court to just order the remaining balance of that 93 days for him. I believe that will allow him to complete the full sentence on his bond violation prior to the sentencing. Thank you.
75 days since his arraignment is not when he violated.
Here, I apologize. You're correct. The violation happened on June 6th. He was arraigned later that day on the whatever the time was, possession of methamphetamine. Since that time, he served 75 days. On the use, and I believe the no contact.
I'm trying to figure out how he spent 75 days when he was out on GPS tether in July. To have multiple GPS violations. I don't think I revoked his bond. Or remand him, I should say. Until July 23rd.
Until July 23rd, right.
So he wasn't serving time from June until July. He was free. I had him on GPS tether.
And what Mr. Seaberg is indicating to me is between June 5th and July 6th, he was in custody of the county jail on the June 6th to July 5th.
June 6th to July 5th.
Yes.
Why was he in custody?
On the what is now the use of methamphetamine. Our notes are a little spotty from the arraignment on that.
I get it, but that's nothing to do with this because he wasn't being held on this.
Right, I'm unsure when he was arraigned on the bond violation.
He was arraigned on the bond violation on the very next day, June 7th. He was not held on that bond violation. I didn't remand you until I got the series of the next bond violations. So yeah, you were remanded until July 17th. Then by the magistrate per my order. And then July 23rd is when I had to suspend your jail calls.
So I believe that corrected math is 28 days.
90 days, Ingham County Jail credit 28 days. You're all set.
I remember there needed to be a plea to the domestic violence charge on that file as well.
Okay, my understanding is, the plea was going to take care of everything, no?
It was a plea to the domestic violence and the use.
Okay, let me find the sheet. I think I hit it in one of these things. Okay, plea to this and charged in 24-01395. There's actually two sheets. Look them both in there. Okay. All right, you're still under oath, and in this file, you have a count of domestic violence. And the same rights would apply. You do have the right to have the presumption of innocence on this, and require the prosecution prove your guilt at a trial. You understand that? You have the right to see, hear, and question in court any of the witnesses they intend to call against you, or you can waive. Or you have the right to remain silent, not have silence used against you, or you can waive your silence and testify for yourself, or call witnesses to testify on your behalf. You understand that? And you want to give all your rights on this file as well to enter a guilty plea. Anybody threatening you to do that? Any promises being made to you? As to domestic violence and file number 24-01395, how do you plead? Factual basis, nothing.
Thank you. Mr. Seaver, on or about April 12th of this year, were you present at 829 Euclid Place in Lansing, Michigan? That's Ingham County, Michigan. And at that time, did you offensively touch or attempt to touch Kelly Hooks? And is that a person that you have previously lived with or been in a dating relationship with? You did not do that in self-defense. Thank you, Your Honor.
Any questions from the prosecution?
Briefly, Your Honor, Mr. Seabrook, how did you offensively touch Ms. Hooks? And that was against her will? People are satisfied.
So you hugged her like a bear hug, is that what you mean? But yes. Okay, the court is satisfied with the factual basis of accept your plea. Find it to be freely, voluntarily, and intelligently. This matter will be set for sentencing as well, October 22nd at 9 a.m. Okay. Do you have any questions for the court? Any additional matters for the record on these files?
Not for the people, Your Honor. Thank you. Your Honor, just you had asked for the advice of rights earlier. I do have that.
Oh, yes, please.
Thank you. I have nothing further.
I think all the other files should be on a citation, so those will be discussed further.
Thank you. Thank you, Your Honor.
You're welcome. Which matter? I believe. Curtis. Right, yep, that one. Oh. See interpreters here?
Yes, sir.
You're here for a 10:30 matter?
Yes, ma'am.
Okay. Let's see, Ms. Sutter, I issued a.
By my name, haven't even brought me up yet, so I don't know.
You should have bench warrant for Cotton here.
You did.
I did.
Okay. Just for my own sake, You received the email from me.
I do
yesterday.
have the email that at 4:19 yesterday, she said she was a victim of assault and was taken for medical treatment. It's almost 24 hours later. Unless she was admitted to the hospital, she should have been at court today.
I understand, Your Honor. I haven't yet heard from her. It was an attack by a family member, but it sounds that I'm not sure if she's still hospitalized or was released early this morning. I can attempt to get in contact with her, but I'll also note the file here.
Sounds good. Thank you. Okay, let's see. Pritet, who's representing Pritet?
I am, Your Honor.
On the record, in the matter of the people of the state of Michigan versus James Pritet?
No, I apologize. I have not had the opportunity to speak with him yet.
Oh, okay. I'll put him in the meeting.
Thank you very much.
I think we're ready to go on Carter. Whenever you want.
Okay, on the record, in the matter of the people of the state of Michigan versus Douglas Lee Carter Jr. File numbers 24-0193233 and 34. Council appearance, please.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Jacob Rowley on behalf of Mr. Carter.
Today's date set for a pre-trial on each file, and they are for dog at large and 2 dog vaccinations. How are we proceeding?
Yes, Your Honor, I have received proof of both the licenses for the license charges and proof of the fence being fixed for the dog at large charge. At this time, people would move to dismiss in the interest of justice.
Motion to dismiss is granted. You're all set, Mr. Carter.
Huh?
You're all set. Your cases were dismissed.
All right, thank you.
You're welcome.
And Ms. Schroeder might be on the PCC for that. I think Mr. Samuels is on the sentencing.
Oh, let's see, dismiss this. There's Ms. Schroeder right there. You're free to go, Mr. Carter.
My bad, I'm just sitting there watching.
Oh, no problem. Is Chelsea Peterson here at all?
I have not seen her, Judge. I have not been to the jury.
Okay, I'll share bench warrant.
Did not get a chance to call her. I saw her coming down the hall, so you want me to go ahead and have her bring it?
No, he's got a she has a sentence, I think. Whitney Rice?
Yeah.
Has sentencing and their attorney's not here yet. Well, yes, she has 2. Yeah, that's a PCC. I don't even think. Yeah.
All right, I'm here on Whitney Rice for just a felony. For some reason ended up on the PCC right there.
Saw our girl is coming.
I.
You see the report?
Yeah,
Saying
no,
she's
it's,
coming
yeah,
to-
it's like from a few weeks ago.
I think, oh, is it? Okay.
Mhm.
I had my notes, that's why it got.
Yeah, except for PCC today, I think.
Yeah, it's got some misdemeanor files. I think they're in accompanying it.
Just sentencing them to.
Yeah. And those are 2 files that aren't with our office because they got conflicted out to Matt Samuels.
Correct.
My case, I believe, is supposed to be getting dismissed as part of the plea agreement in misdemeanor files, but I guess it got still in, I don't know. So I ended up not.
I think last time the competency eval was requested, so that's why.
No, we entered the competency though.
Yeah, mid-June.
We're gonna go on the record. And the record in the matter of the people of the state of Michigan versus Juan Rulo. File number is J006737. Council can have your appearance.
Good morning, Your Honor. Case number carrying appearing on behalf of the
Rebecca Nybert, serving on behalf of Juan Rulo and Legal Services of South Central Michigan. Juan, can you state your name for the record, please? Oh, Juan, can you take your self off mute? There you go.
Juan Rodolfo Revilla.
Okay, today was the date scheduled for a motion to set aside a conviction, and this is a conviction from 2002, which is destruction of personal property less than 200. Let's see. I think we previously had a date for this, but no one appeared. We reset it. I'm trying to see if I have a response from the AG in here.
And thank you, Your Honor, for resetting this. I apologize for this information not getting back from our attorney that left our office and to when I had been able to pick the case up.
Oh, no problem. I assume something was going on, so I typically on these will give a reset if they don't appear. I'm just thumbing through the file to see if the Attorney General ever responded. It looks like they did, and they have no objection.
Yeah, we do have Attorney General's answer to defendant's application to set aside conviction. Thank you, Your Honor. Yes.
Thank you. And is the county prosecutor taking a position on this?
No, Your Honor.
Okay, counsel, I don't know if you wanted to have an opportunity to guard your client.
Your Honor, yes, if you would like, I can volunteer him and ask him the questions of whether or not he's been doing what he's supposed to, and the questions relating to whether or not he's had too many felonies and such. Mr. Revilla, it's true that you've had more than 3 felonies, isn't that true?
Yes.
But that you're asking the court to understand that you are asking for the one bad night exception through 30th Circuit Court.
That is correct.
Yes. And that you have no convictions for assault of crime to be set aside during your lifetime.
Correct.
And that there is not any criminal charges pending against you at this time.
Correct.
And that you're not convicted of any criminal offense during the applicable time period here, which is 7 years.
Correct.
And that was 7 years has passed since that for all your convictions.
That is correct.
And as Your Honor had mentioned, the opportunity was given to the Attorney General, and of course, the prosecuting official is here. And we believe that circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application warrant setting aside the conviction. It is consistent with the public welfare. Your Honor, we believe that Juan is a man who has changed his life around since the time of his conviction. He stays very busy with his family and working. Juan actually has 4 children, including a 1-year-old. So he has 3 grandchildren, and he has a 1-year-old himself. He enjoys spending time with his family. They go on vacations and have cookouts. Juan and his family attend Lansing Capital City Church every Sunday, and family time is very important to him. Juan also provides for his family financially. He has been at his current job for 4 years. Juan has had multiple back surgeries, which he creates physical challenges to him at times, but he still works very hard to provide for a wonderful life for his kids and his grandkids as well. Due to his convictions, Juan has struggled finding a better job. He strives to find a job that is easier for him physically, but would provide for him financially and the stability for him and his family. He has been denied many jobs previously because of these convictions, but his main hope with requesting the 6-expungement here today and the one in 30th and another one in a different court, Your Honor, is to gain more opportunities, job opportunities to leave these past mistakes behind us. Ultimately, he's asking the court to recognize the changes and commitment that to better his life when considering this request to set aside his convictions, Your Honor.
Thank you. And did your client want to make a statement at all?
Juan, we talked about this and you thought you wanted to just get to what you had told me to mention to the court. Is there anything else that you would like to say?
No, not at this time. I really appreciate the opportunity to be able to get this taken care of.
Thank you.
Okay, I'm happy to see that you are making some strides toward trying to, like you say, clean these things up in your life. I don't see any assaultive actions or any engagement with the criminal justice system since 2018. Based on a review of your file as well as indications made by your attorney today, I think that you do qualify for an exception under the one bad night provision. The court will grant your request to set aside this conviction in file number J006737SM. It'll be dated for today. I find set aside this conviction would be consistent with the public welfare.
Thank you, Judge.
You're welcome.
Your Honor, do you also have the domestic violence, the 94-05306 file is the malicious destruction of personal property and the domestic file in front of you?
Can you give me that file number again?
Sure, 94-05306.
So this is the malicious destruction of property. There's another one. I don't know if I have the file for it. Oh, here, another one. Okay, I do have the misdemeanor domestic violence file here. Let's see. Okay, that both are signed and dated, granted for today.
All right, thank you, Your Honor.
Thank you. You're all set.
Thank you. Have a great day.
You're welcome. You too.
In Spanish or?
Mr. Samuels?
Yes, Your Honor,
Have you spoken with Whitney Rice?
I have.
Okay.
We're
Let's
prepared to
see.
proceed.
We'll have to have her brought up then. Thank you.
Thank you.
Mr. Rowley, were you looking to meet with?
Well, Your Honor, I have Mr. Viltre here. I think we need the interpreter. The Spanish interpreter.
Yes, I'm right here.
She's here. I'll put you all in a private meeting room.
Thank you.
Thank you.
No problem.
And your Mr. Pritchett's also ready. He's so great.
Who's on the Motorola?
Me, Mr. Ross.
Mr. Ross, do you have a first name?
Benny Ross the third.
Okay, thank you. All right, Mr. Pritchett, can you hear me?
Yes, ma'am.
On the record, in the matter of the people of the state of Michigan versus James Pritchett, file number is 23-01702, council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Pritchett is joining us via polycom.
Okay, Mr. Pritchett, today's the date set for a pre-trial. This is for an attempted police officer assault, resist obstructing, and an assault and battery. How are we proceeding on this?
Thank you, Your Honor. And just as a clarifying question, we were having a hard time determining the register of actions. There is still the simple assault charge before the court.
My notes indicated that might have been dismissed at a final pretrial back in January, Your Honor.
Let's see. I do see that. No witness on assault and battery. We now. Yep, you're correct.
Thank you. And I believe we have a resolution regarding the remaining charge today. I think Mr. McCurry is preparing the report for the court to review, but just to summarize, Mr. Pritchett will be entering a the, I believe, added count 2 of disorderly person jostling. In return, count 1, attempted police officer assaulting, resisting, or obstructing will be dismissed.
That is correct, Your Honor.
Okay, that's correct. You're gonna plead guilty to disorderly jostling, sir?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, you can put your hand down. Okay, so disorderly jostling is still a misdemeanor, so you do have the right to proceed to trial in that matter, and you have the right to a jury trial. You understand that?
Yes, ma'am.
You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you, or you can waive your silence and testify if you'd like at your trial. You have the right to see, hear, or question any of the witnesses that the prosecution intends to call against you. You have the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. So you are telling me that you're willing to give up each of those rights today, correct?
I am, yes, ma'am.
Is anybody making any threats to you to get you to give those rights up?
No.
Any promises being made to you in exchange for you entering a guilty plea to the amended charge?
No.
And he's in custody with no release date awaiting trial, correct?
Yes, correct.
You understand that if you plead guilty of this conviction could result in a conviction that you may need to report to a future employer?
Yes, ma'am.
It could also have impact on where you can travel or get immigration status. You understand that?
Yes, ma'am.
As to the amended count 1 of disorderly jostling, how do you plead?
Guilty.
Factual basis?
Thank you. Mr. Pritchett, is it true that on or about June 1st of 2023, you were present at the location of
2701 Trappers?
Thank you, 2701 Trappers Cove?
Yes.
That's City of Lansing, Ingham County, Michigan?
Yes, ma'am.
Thank you. And is it true at that time you did jostle or roughly crowd people in a public place?
Yes.
And in this case, that was an officer?
Yes.
Thank you, Your Honor. I believe it satisfies the factual basis.
Any questions from the prosecution?
No, Your Honor. People are satisfied with the factual basis.
The court is satisfied. I will accept your plea. I find it to be made freely, voluntarily, and intelligently. We have a little bit of time on this because there was several failure to appear, and I know.
Correct, Your Honor. I believe it's been on a 5,000 cash assurity bond since July 26th with the rank date day 25.
Within 25 days, you're all set.
Thank you.
All right, may I have the-
Yes, and thank you. Just give it to her. Yes, we need rice part of it. Let's see. That was done.
Your Honor, if I may, can I speak with the record with Mr. Ross?
Mr. Ross, yes.
Yes, thank you.
Rotary. Do we have either Jamal Turner or Curtis Williams?
So what?
Mr. Turner's here.
Williams? I placed that video hearing to turn hot box. 14 file. What's that? Chillico Correctional Facility in Ohio. I don't know how that's gonna work.
They did log him in once. I just don't.
For the arraignment or another time? I see
Never
where.
another pretrial.
I don't have I have no handwriting in this file. I do see, however. These are indeed. Initial R&D. On the 8th, it's a correctional something department of rehab and corrections. There was a video arraignment scheduled for the 26th of July.
Right there.
That must have gotten changed
We
because
just
it looks like
didn't
he
have
actually
vacation.
had it
They
on
were
the 30th.
separated between the three files.
And that's it's on the 30th.
No worries.
I found it, though. You are correct. It got dismissed as a part of the domestic violence.
Yeah. And the thing is, I don't think
No, no.
which is why I got inside for that pretrial. I don't know if
Yeah, so I always see this little thing here for June 30th. I don't
Yeah, that's
see the
the-
date. I don't know.
They went for the pretrial.
I don't know if they did one for today. Are we getting rice? Did someone get rice?
I heard nothing. I heard nothing.
Your Honor, that PCC should have been in Holly too. I don't know if you got it beforehand. I think we were supposed to file it before today, and it appears our office did not.
You know, if I got what beforehand?
No,
How would I get it if you didn't file it?
apparently Mr. Stevens was supposed to, so I'll defer to him if he didn't.
That was my understanding
It's
from my
supposed to be
communication with them
non-complete.
2-3 weeks ago. That really did not happen.
The notes that I had said that the part of the plea on the DV case was to dismiss the PCC.
Reset via Zoom. You said it's supposed to be Nolly per what?
As a part of the plea on the domestic violence case she's here for, it looks like it was offered to dismiss the possession of meth and breaking and entering case in its entirety. And according to Ms. Schroeder, she has communicated with Mr. Stevens, who confirmed that. I just have a hodgepodge of case notes, so it's hard for me to tell. I have no reason to doubt it.
Yeah.
I don't know plea sheet, that's why I refer to plea sheets.
I think the plea sheet ended up probably with Mr. File, I guess.
I don't have, it should have gone with the file to play. I have all three files here.
James, he's one of the members.
They didn't provide us a model.
I was assured that they would.
Who were they bringing it on?
Andrew Simmons. And I do have the receipts to show.
He probably did say he would send it or something. I don't know why, we always print Nollies.
They asked him if there had been filed.
I know, I-
No, we forgot.
She was trying to take the plea the last time. But she's trying to take the plea for.
They're trying to sentence her. She was already, one of these files, she's already scheduled for sentencing. and then
Correct.
reset The other one with it.
So she
And I
must have,
believe
she
all
must
of
have
them
pled.
got set.
Yeah, so she pled at the last court date to, was it DV? What was it? Plead guilty to count one on docket 24-01811.
It was arson, Your Honor.
Do I even have that file? right now? Oh, yeah, that's what I'm reading out of. Okay, so plead guilty to count one. Upon successful plea and sentence, people move to dismiss docket number 24-01634. She has to be sentenced or we get a nollie.
That's why we're here.
Okay. See, that was, I was trying to confirm with Mr. Stevenson. He was like, oh, yeah, it was supposed to be dismissed.
Yep, successful plea and sentence. People also recommend dismissal of PA 53 and docket number 24-01423, sentence to be concurrent to docket 24-01423. Defendant to pay restitution on docket. That might also have been an issue. Did we get a restitution amount? That might have been what.
I think it was online or a door.
Okay, well, let's
No
see.
case notes about restitution.
Ms. Sutter, you ready on
Mr. Ross?
Mr. Ross?
I mean, I'm not gonna say that.
I don't mind the victim impact statement or case notes about it. Yeah.
On the record in the matter of the people of the state of Michigan versus Benny Ross, 24-02251, council appearance.
Morning, Your Honor. Case Mark Herring appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Warren Sutter here today on behalf of Mr. Ross, who's joining us via Zoom.
Okay, Mr. Ross, today's date scheduled for pretrial, one count of domestic violence. Was there an offer on this?
Yes, Your Honor, there was.
I believe it's a tentative offer that they would need to confirm with their witness prior to officially making it.
Correct, Your Honor. We were looking to set up for final pretrial. I need to make contact with the victims on this case to confirm any injuries or if there were any, as I am concerned there may have been an aggravated domestic violence missed in the charging of this case. But based on contact I have with the victim, there was a possibility of resolving this with a killover agreement to no threat jail or 7694A, but I need to get that approved by the victim first.
And I've discussed it with Mr. Benny, or with Mr. Ross, Your Honor, and we would also request a final pretrial on this.
Final pretrial September 10th at 8 AM. And then jury trial October 15th at 8 AM.
Okay, final pretrial is going to be September 10th, 8 o'clock in the morning. You must appear in person at the court. Jury trial, October 15th, 8 o'clock in the morning, also in person at the court. Do you have any questions today, sir?
No, ma'am.
additional matters for the record, counsel?
Nothing further from the people. Thank you.
Nothing further.
Okay, you're all set, sir.
Thank you. You guys have a nice one.
Thank you. Ross. Jamal Turner, no Jamal Turner.
He's here, and he's pro per, Your Honor. I believe we're setting that one for final pre-trial.
On the record, in the matter of the people of the state of Michigan, versus Jamal Turner, file number 24-02074, council appearance.
Good morning, Your Honor. Case marked hearing on behalf of the people.
Mr. Turner, how are you?
I'm pretty good.
I'm doing well. You're here for a pre-trial. It's one count of assault or assault and battery. You did, at least it indicates to me, request a public defender at the time of your arraignment. Is that correct?
Yeah, but I chose to represent myself because I was wrong. I just want to kind of. So I chose to represent myself.
Okay, so you're waiving your right to counsel?
Yes.
Okay. You understand it's a misdemeanor, so the maximum penalty is 93 days and or $500 in fines, correct?
Yes.
Was there an offer on this?
I have not had a chance to extend one yet, Your Honor, because I haven't been able to make successful contact with the victim, and I was waiting to see if an appearance would be filed. Our intent was to set this for a final pretrial, see if I can make victim contact and kind of go from there.
Pre-trial, September 10th at 8 a.m. Jury trial, October 22nd, 8 a.m.
Okay, final pretrial is going to be September 10th, 8 o'clock in the morning. You must appear in person at the court.
So, man, September 10th at 8.
That's correct. And then there's an October
22nd.
October 22nd is your jury trial date. Also at 8 o'clock in the morning.
October 22nd. Yeah.
That's correct. And so that form that she just gave you, both those dates are listed on there for you, okay? Do you have any questions today?
No, ma'am.
Any additional matters for the record?
Nothing further from the people. Thank you.
You're all set. Thank you. Let's see. People still meeting. Have a good one, sir. Yeah, I don't know if we're gonna put Williams on though. Do we have Rice here?
Yes.
Okay, we're on the record. In the matter of the people of the state of Michigan versus Whitney Rice, file number 24-01423, 24-01811, 24-01634. Council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
And Matthew Samuels on behalf of Whitney Rice.
And Attorney Aaron Schroeder also on behalf of Whitney Rice as to file number 24-01634 FY.
Okay. Today's the date set for sentencing, two files. That's file number ending in 1423 and then 1811. I do have an updated report from probation. It was dated prepared on the 14th of August. Did you get a copy of that, Mr. Samuels?
I did not, Your Honor.
Okay. Update for the setting. Did someone send him an update?
Is it an update or is it just about the?
Yeah, so it's updated report, it's gotta go to the attorney. It says that the update, essentially, it's 2 paragraphs. It said that they did a verbal statement regarding the incident on August 2nd with probation and the victim. After a long verbal statement, the victim informed the probation officer that the statement did not sound like him, despite him giving the statement moments prior. He was told to send a statement via email to the probation officer. As of the writing of this, there was no statement provided from the victim. It also states that there are several incidents between the defendant and victim in the past year that suggest the defendant will not follow orders from the court if she is placed on probation. In case number 24-01423, the defendant refused to take responsibility for her assaultive actions and denied use of drugs despite being arrested with methamphetamine on her person several times. It is recommended by probation that the defendant be given a straight jail sentence, referring all fines and costs to collections. That's the update in the file.
Thank you, Your Honor.
She did, okay, she did plead guilty at the last appearance. And I set this out, restitution was to be determined. Have a restitution amount at all?
Not that I can see in the file, Your Honor. I have no notes indicating it, and the police report does not state any specific dollar amount or request for restitution that I can tell.
Okay, sounds good. Mr. Samuel, you can make allocution.
Yes, thank you, Your Honor. Miss Rice has been in jail for about 3 months now. So she has hit the 93 days, I believe. She has a total of 93 days on the one file. As far as the arson goes, not quite sure what has happened there. What I will say about Miss Rice is that since she has been in jail, she has been taking medication. She has been doing plenty of all sorts of programming that the jail offers. She plans on continuing with a lot of the program, including AA parenting, the LLC battery, which she can do at LCC. So with that said, Your Honor, I do think that time served is appropriate at this time. As Miss Rice has done quite a bit of a sentence and probation, she is willing to do probation, comply with probation. However, I think it's unnecessary at this point, Your Honor.
I'll mix these files up. Let me just get back in order. This is the person file. Okay, as to 24-01423, she has been in custody. My record reflects since May 17th. A creditor time served on that. File number 24-01811. Doesn't have any time on that file. She was given a PR bond. Right on June, let's see, 16th. She was given a PR bond. That bond was never amended or changed. I don't have any restitution set on this matter.
Well, then, Your Honor, we would ask as part of my allocution on that one, that you take into account that she has been in jail since June on these files. I know that she doesn't get time on that, but we'd like you to take that into account.
Okay, I mean, I'm taking it into account, but that she was in jail because of another file, not because of this. Again, allegations of arson. Not allegations, she pled guilty at this point. And she's not otherwise a good candidate for me to place on a term of supervision with the court. And I even have some records here in the file with pictures of, I guess, some damage because of the allegations. You're, yes.
I'm sorry I apologize. We did her arraignment, public defender office on this file, the arson file. Our notes indicate what little we had before we subbed it out, that she had a no bond she was issued on this because she was on bond pending resolution of the other file.
I recognize, I don't know what your bond said, what your notes indicate. The court doesn't speak through the public defender notes, the court speaks through orders. Our order in the file, as well as the note that the magistrate who arraigned her put in here, 2,000 personal recognizance is what she put.
All right, thank you.
I don't see where that was ever amended or revoked in this file. My only time touching this file actually would have been August 2nd. When she pled guilty.
Thank you.
So she doesn't have any time, and I am not going to enter a course of supervision just for her to completely disregard court orders. And our past practice has indicated she's not someone who follows court orders. As to file number ending in 1811, she will get a sentence of 93 days in Ingham County Jail. They updated it. This one is really not it. She'll be screened and treated, or screened for any eligibility on treatment, that is, while she's in custody, because the report, at least in file number ending in 1423, did indicate that she did meet some criteria for alcohol use disorder and relapse, so she needs to be screened for treatment there. Any additional matters for the record on those two files?
If I may, file number 2401811, the arson case. I did look at the police report. It appears there was an estimation of $1,000 in restitution.
You just, I'm sorry, your voice
I would need
dropped
to
off.
confirm that with the victim. I'm sorry.
You wanted to set for a further restitution hearing, or?
My understanding with the plea that the plea offer was that the defendant would agree to pay restitution in any amount that was determined on these files. So I don't know if we need a restitution hearing, Your Honor, but it is listed as an estimated amount, so.
Okay, well, yeah, it's just the defendant to pay restitution on docket number 24-016 before. The issue is that we don't have an amount.
Your Honor, and that's why we waited for the sentencing to be pushed back 3 weeks as opposed to doing it on August 2nd, was so that the people could find out what a restitution amount was. This was not done.
I recognize that, and the way the plea, the one thing Mr. Stevens did was very clearly articulate how this plea was supposed to go, even down to the fact that we have Ms. Schroeder here today because we could not dismiss her felony because he had it tied up to the sentencing. So that's why she's here. And it says the defendant's gonna pay restitution on the actual case that Ms. Schroeder is here for. And we don't have an amount. Not really sure. The restitution is not tied up to the arson?
It is, Your Honor. That's the case I'm referring to.
Yeah.
The amount listed in the police report on that has been discovered and disclosed to both defense counsel is $1,000.
Well, the concern that I have is that the arson file is 24-01811. And the plea sheet says she's gonna pay restitution on 24-01634. Which is Ms. Schroeder's case. Which is the case that's gonna be dismissed. So then that needs to be changed, correct?
Yeah, my understanding, Your Honor, just one moment. I'll reread the.
Which would make it easier because we can't really order restitution on a closed file anyway, so we have to monitor it on a file that's open.
I'm grabbing the most updated note from Mr. Stevens that I have in our file. On August 2nd, the note that I have is that the defendant was to plead guilty on count 1 on the
24-010-811.
correct.
That's the arson
Upon
file.
successful completion of plea, we're moving to dismiss 241634, as well as recommending the PA 53 associated with 241423 was dismissed, and defendant agrees to pay restitution. It does say to be determined on both dockets. It looks like we have it temporary. Like Miss Petrosky made contact or attempted to make contact with the victim.
That must have been a long time ago. When
Yes.
Mr. Stevens has finished this one. Well, the concern that I have is I recognize that's your note, but I would have read this offer on the record, and which would have mean that the restitution was tied up to 24-01634. So are you making a motion to amend that so that it could be tied up to the arson file if it's restitution on the arson?
I think that would be more appropriate, Your Honor, yes.
Okay, so we'll do that. That will not bind Ms. Schroeder's case up. And she's been sentenced, so we'll print a nollie out on the felony so that she can have that dismissed per the plea agreement. And then if the prosecution comes up with the confirmation of restitution amount, they can make a motion to the court for a hearing on that. At this point, I'm not gonna reset it because we reset it for this purpose.
Yes, sir. Fair enough. Thank you.
And it seems like since the time, and you're looking for the victim to give that amount,
Yeah, it looks like
he's had contact with the probation and he's not been responsive to the last request, so.
that's my guess, Your Honor, yes.
So no restitution will be ordered at this time. Any additional matters for the record?
Yeah, Your Honor, I think there's one more thing, as far as the plea agreement went, was that the arson file should have ran concurrent with the previous file, the domestic violence file. So I think that she should earn, I think that way she would earn some time based on that agreement.
Yeah, well, the sentence can't be concurrent if she doesn't have any time.
No, it would be concurrent to the domestic violence, which she had 93 days on, including the time that she was sitting in there, even though she had a PR bond.
Yeah, well, that was a sentencing, that's a Killebrew agreement, so I'm not accepting it. So are you saying your client wants to withdraw her plea?
I don't know the answer to that. I'll leave it up to Miss Rice if you want to withdraw your plea. I don't know that it's going to get any better.
It's a little difficult for her to communicate with you in private right now.
I understand that, Your Honor.
I've been contacted about the case.
Okay. Did you want us to put her on in Zoom so you can meet with her privately?
Yes, please.
Your Honor, could I apologize. Can I make a brief record? I know the court has made its ruling, but I would like to. Your Honor, I don't believe under the Crime Victims' Rights Act, we can't just move one restitution for a different file that wasn't originally ordered as part of the plea agreement. I also acknowledge that their notes here are kind of all over the place, but I know that then I also acknowledge, if I understand correctly, the court's not ordering restitution at this time. We're awaiting any further update, and the prosecutor has to make motion regarding that being reopened. Is that correct?
Well, my understanding is that the restitution is a result of the arson.
Which was, and that was not was originally what we signed on to. And that's
what do you mean what you signed on to?
In terms of the plea agreement, Your Honor. Because
then the plea doesn't make the whole plea can be withdrawn then, because the plea would make no sense. I don't even understand why there would be restitution order on a file that's being closed if the restitution doesn't even connect to that file. It makes absolutely no sense. It had to be a typo.
Your Honor, may it be heard?
Yes.
The case note that I read from Mr. Stevens ends that defendant agrees to pay restitution TBD on both docket numbers 24-01-811, which is the arson case, and 24-1634, which is the case that Ms. Schroeder's talking about. So we're not, the agreement included both the arson case and Ms. Schroeder.
So Ms. Schroeder's case had some restitution as well. That was the possession of, no, that was the other felony.
I think there was a potential for restitution, Your Honor.
Is it the same victim though?
No.
No, Your Honor.
So there's been no restitution submitted from either victim?
Correct. Based on my review of the case Ms. Schroeder has, I didn't see any restitution, Your Honor, not even listed in the police report. So I don't have a noted request for that.
Got it.
The arson case is just the one where there's the estimation of about $1,000 a day.
And to address your concern, under your understanding of the Victim Rights Act, your case was being dismissed. We can't order restitution on a dismissed case. It always has to go on the case that remains open.
I appreciate that, Your Honor. I just wanted to make my argument heard. Thank you.
Yeah, we can't, and we've had issues with the clerk's office with doing that, with trying to order restitution on a file that's being closed. Can't do it.
I understand.
So we can order on your case, but your case has to remain open then, or she has to pay at the time that it's ordered. Either way, there's an offer in that included, I think he just missed putting one of the file numbers on this one when he got down, because that was the last thing that was written on this plea sheet, which was to pay restitution on that docket number ending in 1634. He's made a motion on this record to include what his belief from his notes was to have restitution paid on 24-01811, which makes sense because part of the restitution includes arson. But at this point, no restitution is even being ordered, so it's a moot point at this point.
Very good. Thank you.
Thank you. And we'll get Ms. Rice on a device so that she can meet with Mr. Samuels privately And for your matter, we'll get you a copy of Nolly in just a minute.
All right, thank you, Your Honor.
No problem.
Your Honor, do you want us to come back on record after we meet?
Well, yes, because I'm thinking you're meeting with her to see if she wants to withdraw her plea.
Okay, yes.
Let's see, Mr. Raleigh, you're ready to go?
Yes, Your Honor, we're ready.
Okay. On the record, in the matter of the people of the state of Michigan versus Yamil Vre, file number 24-02235, council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Jacob Raleigh on behalf of Mr. Viltre.
Jake Riley, de parte del señor Viltre, el caso es de Yamil Viltre, el caso 2402-235.
Interpreter, raise your right hand. You solemnly swear or affirm that you'll interpret in the matter before the court completely and accurately and not divulge confidential communication, so help you God.
I do, Your Honor.
Thank you. Today's the date set for a pretrial
Hoy es la fecha para un prejuicio
for child abuse fourth and a domestic violence.
es para violencia doméstica y abuso de un niño.
How are we proceeding?
¿Cómo vamos a proceder?
Your Honor, we are setting this matter for final pretrial.
Estamos haciendo para un prejuicio final
To allow some more time to contact the victim due to the language barrier about the offer.
para hablar con la víctima para a ver qué se ofrece.
But once I contact the victim and hopefully get her approval,
Ya cuando me comunique con la víctima y tenga su aprobación,
the offer is intended to plead to domestic violence under 769.4A with a Killebrew agreement to no upfront jail, and we would dismiss the child abuse charge.
porque se despediría el cargo de abuso de niño, sería se declararía con violencia doméstica bajo el 769.4A.
Sure, sounds good.
Final pretrial, September 10th at 8 a.m. Jury trial, October 22nd.
Okay, final pretrial is going to be October 10th, 8 o'clock in the morning in person at the court.
Ok, el prejuicio final va a ser la última cita va a ser el 10 de octubre a las 8 de la mañana, aquí en el juzgado.
Jury trial, October 22nd at 8 a.m.
Y para escoger un jurado va a ser el 22 de octubre a las 8 de la mañana.
Your Honor, I think you said October 10th for the final
I'm sorry,
pretrial.
I should have said September 10th. So the final pretrial is September 10th at 8 a.m.
Es el 10 de septiembre, no octubre, a las 8 de la mañana en el juzgado.
Do you have any questions, Mr. Vre?
Señor Viltre, ¿usted tiene alguna pregunta?
¿Preguntas? No. ¿Sí o no? Sí, sí o no. No.
No questions.
Any additional matters for the record, counsel?
Nothing for the people.
Nada por la gente
And nothing for the defense, Your Honor.
y nada para la defensa, su señoría.
Okay, you're all set. Thank you.
Ok, está listo. Gracias.
Well, this should
Mr. Martinez, we're not gonna withdraw our plea. Do we still need to go on record?
Yes, I believe the judge will need to call the case because we'll let her know that the plea is not being withdrawn and will proceed. And
Okay.
Okay, back on the record in the matters of Whitney Rice. And while Mr. Samuels, while you were meeting with your client, the victim did appear, he's present in the courtroom.
Okay,
Did your client wish to withdraw her plea?
no, not at this time, Your Honor. Thank you.
Okay, and then do you now have a restitution amount?
Yes, we do, Your Honor. The restitution request will be that $1,000 amount that I stated earlier.
Also, are you disputing the restitution amount?
No, Your Honor.
I believe, Your Honor, Mr. Holbert did want to make a statement before sentencing it.
Well, we've already sentenced her, but he can make a statement. He can come forward. That's good. You can have a seat there. If you want to state your first and last name and then spell both for us, sir.
Robert Holbert, you said spell that?
Yes, spell it for the record.
ROBERT HOLBERT.
Okay, and you were the victim on the file. Let's see the victim on.
Both the domestic and the arson, Your Honor.
Okay, sounds good. And you wanted to give a statement. You were a little late. We've already sentenced her. And I don't know if the prosecutor advised what the sentences were, but she's still gonna do 93 days in Ingham County Jail. And you wanted to give a statement.
Yeah, I just, wanted to express the report that, obviously, I mean, I didn't want to press charges in either matter, but it just kind of got picked up. And like that being said, is, Ms. Rice and I, we've been through a lot of, ups and downs in our relationship, but, it's one of those things that I am, I just want to see her, back at home, with me, which can't even really be at home right now because things have kind of come to a standstill where, the city won't lift the red tag without her out, or, there because her name is on the house and everything. And like, I almost feel like, despite everything that, has gone on in our relationship, at the end of the day, I mean, I just want to see her do well and succeed in life as well as myself, and we've definitely had a lot of trying times, but, I still love her at the end of the day, and things have, just kind of become stagnant even in my life without her around, just because we have helped each other a lot and, kind of enable each other in good ways,
You say you enable each other in good ways?
Yeah,
Not in bad ways?
well, bad ways as well, but I feel like those have been getting less and less, I mean.
Maybe less for whom, you or her?
I would say both, you have to see the earlier days of our relationship, but, point being is that, I just want to move forward with her, and I feel like a lot of the things that if you were to just look at it on paper, they might look at it as, punishable, but.
If I just look at it on paper, you're
Well,
saying?
from my eyes, from firsthand experience, it's more one of those things that, those enabling in bad ways, really, there's areas of everybody's life where we just need help, and I know she definitely helps me, and that's all I want to do is help her, so we can succeed. But it's been kind of hard, and I know that part might be looking at jail time. You say, you've already sentenced, but I still just wanted to make it known to you that, I never want to see us set back by things like jail time or absence of, having the other one there to support, ourselves. Because that's one of the hardest things, without her around is not having that, person behind you. So, like I said, I know looking at it on paper, you might see, what seems like a lot of bad, but it's like, you know, with the news, for example, they tell you a lot of negative things. So you don't necessarily hear about all the good things that happen. You know? So it's kind of same with our relationship. There's a lot of good there, you know, but I just want to get back to working on that with her and, you know, move forward.
Anything else you want to add, sir?
I don't believe so.
Thank you. I appreciate you coming in today and giving a statement. And I can appreciate and understand that sometimes in relationships, not even sometimes, all times, every relationship, there's going to be good and bad. There's no relationship that doesn't have good and bad. But this is not an issue that we're just looking at paper. We have 3 files on my desk right now, all from this year alone. One charged with arson of a personal property with photos of the items that were charged. We got possession of meth. We got breaking in and in without the owner's permission. We got a police officer assault, domestic violence. We're not just looking at things on paper, nor are we just looking at things from a skewed perspective. Because the law is not going to come in and get involved in your relationship just because you have some bad times. Because anybody in this room that's in a relationship, their relationship has probably suffered or endured some bad times and some good times. The law is coming in when your actions violate the law and put others at risk. And I disagree with the statement about whether or not seeing someone set back because of jail time. The sentence of jail time is not what caused the setback. The actions that brought you before the court that resulted in the sentence is what caused the setback. And I'm pretty liberal when it comes to probation. She's not been a good candidate for that. She's not even really been a good candidate for someone to be out on bond, because it resulted while on bond, we got more cases and we got some violations. Right? She needs some help, and she's got to make a decision that she's going to get that help. I don't know what's going to happen as it relates to you and her relationship outside of that, but you shouldn't be enabling each other. You should be supporting each other positively, and if I had to look at these files, I don't know that I would agree that you're enabling each other positively because of the nature of the charges and the convictions just in these 3 files alone. So what you all intend to do with your relationship after her sentences have been completed between you and her, I wish you the best. Restitution will be ordered in the amount of $1,000. And she'll complete her sentence. Ma'am, do you have a question?
Yes. With the cases that I'm gonna be in jail for, the arson case, is there a still standing no contact order, or is that not in existence anymore?
No contact order is going to continue. You mean for him to call you while you're in jail? Is that what you're asking about?
Yes.
I don't think I restricted her phone calls while she was in jail, so it's the prosecution planning on her continuing no contact order.
Your Honor, Mr. Holberg is here. We haven't had a chance to specifically discuss this. I think he'd be the best source of whether or not he wants no contact to continue.
I would not. We've been trying since that got initiated. I just wanted to see that.
So,
it would be nice to feel like I could answer phone calls and not have her be penalized because of that.
I just want to make sure I'm putting this on the right time. actually. The no contact is on the file that she's got credit time served on, so
Yes.
I don't have anything to left. There's the file she's serving on, there's not a no contact order in place. So you're free to continue your communication at this point if that's what you want to do. Okay? Any additional matters for the record?
Nothing further for the people. Ms. Rice has her hand.
Ms. Rice.
Yeah, my last question, sorry. For the time that I've been sentenced, will I be eligible to do the early release with classes?
Yes.
Okay.
Any additional matters? You're all set. Yeah. Mix these files up. Now for shoulder space.